Justice Singh, you heard from the three panelists on their vision. I would like to hear about, what is your overall vision in as short a way possible? What is your overall vision of access to justice? And then I want to go to the floor for some questions, which will be put to you, some special questions for you.
Before coming to that, I would like to revert to Professor Bajpayee's that concern about the changing nature of the litigation before the Supreme Court and other things. What we have to be very clear about our concept regarding access to justice is there are broadly two types of matters are there, either civil or criminal. In criminal matters are not by option, that is by force. Nobody wants to come to the court. And most of the poor people are brought, framed, and they have to come to justice, and then all things start. So it has to be, they don't come there of own choice. In civil matters, people come, so they can afford. That is one of the reasons being why the discussion is going on. This access to justice is only a middle class concept. Not beyond that. Even the poor, they don't have. I have got one recent findings of this place about Jharkhand. Although it was done in context of the persons, mostly tribal people, who were detained under CLA and VNP Act and other thing, calling them less extremists and other things. This was done by research has been done by a Bagicha ISA NGO group, published, situated in Namkom, about the denial of the bail and other things, how their cases are handled. I could locate it in Economic and Political Weekly. They captured it, no other newspaper. Even the local newspaper, they did not capture. When I read that Economic and Political Weekly review, then I got this.
Yeah.
It's a very 92-page report. And the way poor people are being detained for a flimsy matter, say, allegation goes like they were sheltering the extremist people, they were supplying the food, or they were supplying material. And for years and years together, they remained. And for them, there is no access to justice. Because under compulsion, they have to be before this court. And the entire finding is very, very, very frightening. About 70% belong to either ST, SC, and OBC, voiceless people. So a challenge is there how to deal with those matters. Unless we are sensitive enough to take up their cases, nobody. My Lord, the Chief Justice was discussing about one case about a tribal remained in custody for 14 years. And the vacation period we had, from Future Special Bench, along with me, we sat. That case was in the High Court, case without evidence. A very funny case. 2 persons were prosecuted way back in 1992-93. The allegation was against one person, he stabbed. He demanded liquor, liquor was not given the village, he stabbed. Another person was co-accused, there was no evidence. It continued for 10 years. Ultimately, one person, the person who stabbed, he jumped the bail. And the person against him, there was no evidence, he was on the trial. This case came under the category of old cases. High Court was putting pressure, it's 10-year-old now, you do whatever do. The judge did is, he convicted this person, against whom there was no evidence, and have not taken any steps about that person who escaped. And 2005, appeal was filed, and 10 times it was dismissed by the High Court. Because one judge said dismiss, nobody cared even to open the file and see what is the evidence, why he is here. So it traveled from bench to bench, which was discussed, and the same order. And after 10 years, fortunately, we don't know, maybe his fortune, Chief Justice came, we sat, and we decided in 5 minutes. Only 5 minutes.
That's an amazing story.